Welcome to the Fund2000.com Real Estate Podcast. My name is Chuck Ham, and today I am glad to have Oli Ham, who is a trustee sale officer and a licensed real estate agent. And she joins us to talk about a couple different interesting issues today. Welcome.
Hi.
All right, so today I wanted to talk to you about our usury laws because you've been watching these files that we've had over the past couple of years, and we're not going to get into specifics of any of our files because we don't want to give away any of our clients' information. But there have been two really interesting files that got into this issue of usury laws. So you got really up to speed pretty quickly on what a usury is, and why don't you explain that to our audience?
Well, as far as I understand, this is the law that prevents you, if you're a private lender, prevents you to charge more than 10% on your loan unless it's initiated through the brokerage.
Right. Well, you're getting into the very details of what we want to discuss today, so that's good. But usury is actually much broader. So the first thing is a disclaimer. This is not legal advice. Anybody who's looking to get into, any of these issues should check with an attorney first. And we also have some advice about how real estate brokers like our office can help you and on this specific issue of usury. So usury is just generally excessive interest rate. That's all it is. So, this is an ancient term. It goes all the way back, to the Bible times. It's in the Bible, usury. Um, Usury only means excessive interest rate. And then, law defines it. In California, it is a loan is considered to be usurious if it's a real estate loan that's over 10%, right? And so California has a cap for usury laws at 10%. And then we have exemptions to that. And you started explaining one of those exemptions. And what is that exemption?
The loan should be initiated or received through the brokerage.
Well, arranged, right?
Arranged. The,
Arranged by the broker. So what happens if it's arranged by the broker? Then what can you do now that you have gotten up to speed on this exemption?
Then you have the ways around it if somebody's trying to sue you, basically, for the usurious law.
Right. So you are allowed, if the broker arranges the loan, you are allowed to have a loan that's more than 10%. It can be 20%. It can be whatever you guys agree to, whatever the parties agree to. Now, this is not an issue for most lenders because there's another exemption for institutional lenders. So you don't need to worry about usury if you're an institutional lender. You're already following all the disclosure laws. I think the issue with the issue that California legislators were trying to address was private lenders trying to take advantage of borrowers with excessively high interest rate. So that's this exemption, because this exemption mostly affects those private lenders, those people that only do a couple loans here and there. They are investors. They might have, 10 loans per year. They're not required, or maybe it's less than 10 loans per year. They're not required to have a license or anything like that. They're private lenders.
Yeah, I actually was wondering why is it so they're allowing you to charge more than 10%, but it has to be agreed upon with, like, I'm guessing, multiple parties. So if you're going through the broker, then there is kind of like a more responsibility, or you're reading the contract. But like, why does it have to be like that? Why can't you yourself just lend the money? It's like, are they trying to get, like, kind of filter out all of these people who is not reading the documents, basically?
Well, you can if you're a private individual that wants to loan money to, say, to a friend or just somebody off the street that you think it's a good investment. They need a loan and they agree to pay you interest on the loan that you're gonna get. You can do it. You don't need to have a broker or anybody else do it. But California law will not enforce that that contract if the interest is above 10%. And the reason why is, like I said before, they just don't want people taking advantage of vulnerable borrowers out there.
So they are making lenders vulnerable.
Yeah, actually, that's true. We saw that in one of our files recently. One of our in our non-judicial foreclosure, you're a trustee sale officer, so you're looking at these files, and we saw two different files go to litigation. Um, One of them had a private lender both of the files had interest rate over 10%. So that's why this was interesting. One of them had uh, arranged the loan without a broker. It was over 10%, and comes and hires us to foreclose. We do it, and then the borrower sues her for this loan that she got, and uh, we can't give a lot of details about this because we don't want to give away any of our clients' information, but this is a common scenario. And then you know about the other file. Why don't you update the audience about the other file and how it's so different and interesting here?
Well, on the other file, it was a very, very similar situation, and the file also, the lender was also being sued for usurious interest rate, and but he arranged his loan through the brokerage, so
Mhm.
it did not apply to him. So the lawsuit was thrown out.
The lawsuit was thrown out at a very early stage. It was very interesting because we get a copy of all the pleadings. In fact, we were named as party in the lawsuit, and I read all the pleadings, and it was interesting because temporary restraining orders, this, do judges grant those freely or are they hard to get?
Yeah, pretty freely because judges want to give you benefit of a doubt as a
Right.
as a party who is borrowing the money. They
Well,
don't
they want to,
lose your home.
right. They give the benefit of the doubt, but it's also just a very low standard to get a temporary restraining order because it's only a short period of time designed to maintain, and the order is designed to maintain the status quo until they can actually hear the arguments on the merits. So judges usually feel pretty confident about, granting temporary restraining orders, um, as long as there's minimal merit to the lawsuit. In this case, what we saw was there was not even minimal merit to the lawsuit because this loan had been arranged by a broker, and there's an exemption, and it is pretty ironclad. You can't really get around it, that they were allowed to have an enforceable contract with an interest rate above 10%. We know we have clients. You and I, discuss our clients in sales who have cash. They're trying to figure out what to do with their cash. And that's kind of the reason why we wanted to bring this up because we know there's a lot of people out there. They have cash. They want to make a good investment. They might not feel good about the stock market. Maybe they feel good about making a private loan. So how can we help? How can you help as licensed agents and brokers? How can we help our clients if they want to make a loan to somebody on real estate?
Well, we do both, but if you're just an agent, uh, you cannot help to arrange the loan, but you can suggest that they can go to a broker and
Mhm.
arrange the.
Right. Yeah, you can suggest that that's probably true, and it's through our office as long as it's arranged through the broker's office. um, then we are able to help our clients do this and get the exemption from the 10% cap on interest. So this is one selling point for working through a broker, even on your private loans.
Our office provide all of this, so it's a one-stop shop. So you don't have to go anywhere. If you come to us, you have the agents, you have the mortgage, you have everything.
Right. And I guess what you mean is not only um, private loans, but also institutional lenders. We broker loans.
Correct.
And we've got, VA, conventional FHA, non-qualifying mortgage loans. Pretty much every single loan out there, we're set up with a lot of boards who we broker loans with. So next topic, let's talk about the NAR settlement. It's been an ongoing discussion this year. You've been doing showings to tenants and buyers ever since this MLS rule change was announced. I don't know if you knew, it's also new law in California that if you're going to show a property starting in 2025, it's going to be law, that in about 34 days that you have to have a buyer representation agreement. Did you know that in addition to the MLS rule change, it's also going to be California law?
I had no idea that that will be a law, but because we already implemented that, it wouldn't affect me.
So how have you been handling it with showings? You need to have a representation agreement. How do you introduce the topic?
Okay, so that was a little bit awkward. In this situation, I was representing the landlord, and I had a lot of potential renters coming through the property. And every time the renter will come over, or even at the stage where I'm contacting the potential renter, like we got a bunch of them through Zillow, I had to make sure that um, they understand that if they don't have an agent, they will have to sign a representation agreement with me at the property. I cannot show them the property if they don't have either agent or representation agreement with me. And that was awkward because people didn't get used to it, and they kept telling me like, oh well, I saw that many properties before and nobody ever asked me to sign anything. So that was kind of like a hard situation because I'm pretty sure I lost a couple of potential renters. They didn't want to sign anything that early on that such an early stage.
Right. And it is awkward, and I don't think it's a good rule. And I actually voiced my concern on this podcast about the rule early on. So the California law and the MLS and National Association of Realtors rule change addresses this exactly how you described. If you're a buyer or a tenant and you want to go see property, the agents have to have a representation agreement before they can show you the property. And for some reason, this is what they thought was going to be the correct response to an antitrust lawsuit. The antitrust lawsuit, do you remember the issues there?
Yes, it's about the commission. So I also don't know how this will be the good response to that. I'm not saying that this is a bad rule because I do have an example that kind of how this rule actually helps in some way, but people can
Well,
figure it
I
out.
want to hear your example, but first I'll just briefly explain that the NAR lawsuit that got settled this year basically addressed this legitimate concern that sellers at an early stage before a buyer was even in under contract, before anybody could possibly know who the buyer could possibly be on a particular property, the commission to that buyer's agent was already negotiated through the seller and it was offered on the MLS. And that created an antitrust issue because the it was being agreed to without the participation of one of the parties, the buyer. And that was unfair to the buyers because that's 2.5% additional. In most cases, it was a 2.5% commission that the buyer had no opportunity at all to negotiate. And it was offered to their agent. And all of a sudden, the buyer is obligated to pay their agent that 2.5%, or that additional 2.5% that they had no opportunity to negotiate. Does that make sense?
Yeah.
Okay, so what was the example that you wanted to share where the representation agreement is actually good?
So I had a couple of cases where when I will ask potential renter if they have an agent, they will respond no and would want to see the property, and they will come and at a later stage they say, "Oh, I have an agent." So my agreement with the landlord was a certain commission if potential renter does have an agent, and a bigger commission if they don't have an agent. So I represent both of them. So I do all of the work, I get more money. And if I start with doing the work and at the later stage I find out, oh, they actually have an agent, that doesn't help me because I already did multiple steps and a certain amount of work. And then they decided, oh, I can bring my friend and my friend can get a commission.
Right.
So that's how I felt at that moment. It kind of protected me, even though it was awkward in the first stage. But also, it shouldn't, for me, it shouldn't even being kind of awkward because the representation was saying that I'm representing them for only one this specific property and I don't require any money from them. So I think a lot of people when they say oh representation agreement they think about money, and it's very hard to change this mentality even by pointing out like hey you're not going to pay me anything. It's just an agreement that I'm representing you. They don't understand that there are different ways of me being paid, you know what I mean?
You mean like through the seller?
Through the seller, yeah.
Well, we should back this up a little bit and say it was always the best practice for an agent before they start working with any client to have a representation agreement. You've heard that before, right?
Yes, but we also use it as gaining potential clients.
Right. So the issue really is why are we forced if we've never even met this person and we're just going to provide a service to our own client, the landlord in this case for you, to show a potential renter, somebody that we've never met before, who is not really going to want to sign a contract with us unless they know for sure that, they want to work with us and do this transaction. Why are we making them sign a buyer representation agreement? Well, that's a legitimate point. But you also raised a legitimate point, which is something we've always said. You need to screen these people, see if they already have an agent, see if
Hmm.
there are any other issues that would require the agreement up front. Now, it's not going to matter anymore because law and the MLS rule change is already in effect. We need to have the agreement. So everybody's doing it now, and buyers and tenants are quickly getting used to this. But there's an additional concern, and I expressed this concern. I think it was a couple months ago on a previous podcast. I don't think that this rule change actually helps with antitrust issues because what it does is landlords or let's say listing agents, um, they are now more likely to double end a transaction because all they have to do is before they list the property on the MLS is have an open house or something like that and get all the buyers coming without their agents and say, if you want to buy this, you have to work with me. If you want to see this property, you have to sign this agreement. Or even if it's not an open house, somebody might contact the listing agent. And I mean, theoretically, the MLS is saying this puts in a burden and an incentive on the buyer's agents and the tenant's agents that if you're working with a, a tenant or a buyer, you need to get your representation agreement signed. But it's actually forcing a lot of tenants who might not even think of themselves as a tenant yet, and prospective buyers who might not even think of themselves as a buyer yet, to sign agreements with people who they might not have signed agreements with in the first place. What do you think of that?
Yes, and we it's a very tricky situation and it raises a lot of ethical questions. We had clients recently who got themselves in this kind of situation where they just came to see an open house and the agent was saying, okay, I have another house that I can show you. She brought them to this house. They liked the house. They wanted to buy it. They wanted to call us. And she said, no, I
The
already
the
showed
buyer, the buyer, our
the
buyer clients we've been working with for a long time wanted to call us, and what did she say?
and she said, no, I already showed you the house. You are not allowed to go with any other agent. So she basically prevented them to call their agent and forced them to go into contract with her without even buyer representation agreement. She did not ask them to sign anything yet, but she threatened them that this house will go on the market if you will not go with me, basically. So there's a lot of like ethical issues coming out of this situation, and I understand that this will be the law right now, but still like there's a lot of forcible situations here where agents kind of have a very shady power I would say.
Well, the interesting thing is in order for the National Association of Realtors to come up with a settlement, they did not need this requirement. This had nothing to do with the original issue of the NAR lawsuit. The original issue, again, of the NAR lawsuit that is being settled, and this whole discussion that we're having right now is because of this settlement. The original issue, remember, is offering 2.5 or any commission on the MLS. That was the only issue.
It's about
Now, right, it's
negotiating the
about
commission.
negotiations, and requiring buyers or tenants to have a buyer representation agreement has nothing to do with whether the commission is offered on the MLS. So I want everybody to understand, everybody who's listening to this, that this requirement has nothing to do with the original antitrust issue. This is something that the NAR negotiated for with the parties involved, that and everybody agreed on this settlement, and the court seems willing to sign off on it. At least we haven't heard otherwise. But and this is why I'm bringing this topic up again in today's news. I'll read it to you. The Department of Justice, they're a party to this lawsuit because this is antitrust, right? Um, expresses concern. Maybe they're not a party. I don't know if they're actually a party, but they do have an interest in the lawsuit. So I think they can have an objection or something like that. I'm not sure how the lawsuit works as far as the Department of Justice being a party or not. The headline is DOJ expresses concerns about NAR buyer agreements. So they're addressing this and they're objecting. The agency, meaning the Department of Justice, also states the pending class action settlement shouldn't stop future antitrust enforcement. It's a very short article, so I will read it. The U.S. DOJ, Department of Justice, on Sunday published an opinion that may impact this week's settlement agreement, calling for the National Association of Realtors, NAR, and the other parties to pay nearly $700 million to settle a class action lawsuit with a group of home sellers, right? So the little intro. The class action suit challenged the long-standing practice of unilateral compensation to buyer brokers of 2.5 to 3% of the cost of a home being purchased, right? That's what we just got done saying. It is a fee that many prospective homebuyers didn't realize was negotiable. The suit maintained that this practice raised the cost of buying a home and had to be paid no matter the quality of services or whether the homebuyer was willing to pay for such services at all. The DOJ did not speak directly to the settlement agreement, but instead spoke to provisions in the agreement. So now here's where the article and the DOJ is saying, here's this separate thing that has nothing to do with that offer of compensation. So instead, they spoke to these provisions in the agreement, including requiring buyers and their brokers to enter a written agreement before the buyer tours any home. That's our issue, right?
Hmm.
DOJ officials say the provision raises independent concerns under the antitrust laws. It, what they mean is new concerns. It's like we're going from one concern
To
related
another
to
one.
antitrust to a completely different one. So DOJ again says the provision raises independent concerns under the antitrust laws, which could be addressed by the elimination of the provisions. In other words, the DOJ is saying it shouldn't be there.
Yeah.
This requirement, and that goes for California law too. Whether it's MLS, the MLS is affected by the settlement agreement because it's
Hmm.
National Association of Realtors. We work under the umbrella of National Association of Realtors. But California is going to be subject to this law too, I think. I mean, if this gets more and more, receives more and more legal challenges, California, I think, could also be. Um, I don't know how that's going to play out because I don't know, if California is or governments are allowed to allow monopolies. We know that, but I don't think this is one of those monopolies they'd be allowed to have because we have so many federal laws that protect against that type of thing, I would think.
Yeah.
So we could address this independent concern by eliminating the provision or that the settlement does not create any immunity or defense under antitrust laws. So what they're saying is either remove it or you're going to get sued.
Okay. That's, yeah, it didn't make sense to me too. Like, as a response, it did not make sense to me.
It doesn't make
All
sense.
all we need to change is negotiation on the commission. Like
That's it. Yeah.
that's all it is. And so creating a bunch of new things, shady things, will not help
Well, yeah,
actually.
but let's talk about that in a second. But the DOJ says that such agreements closely resemble prior restrictions among competitors that courts have found to violate the antitrust laws in other proceedings. These agreements could limit and not enhance competition for buyers among brokers. It's not going to solve the problems, what they're saying. So really what happened was the NAR could no longer enforce the monopoly that they had one way, or they could no longer strong arm the monopoly they had one other. So they're going to try this other way.
Yeah, they're gonna shift it.
And this is crazy because here we are, members of this association of realtors at all levels, national, state, and local. And we benefit, right? We benefit because does our commission not increase because of monopolistic antitrust practices? Yes, but we're not
Yeah,
one of these parties that's trying to make it that way. We're just a part of the system that we have no other real option. We're trying to explore other options, and we are voicing our concerns and agreeing that the difference with us is we are a small firm and we can justify our value pretty well. We work hard for our clients, don't we?
yeah, we do.
And we do a lot of good work for our clients. What's the quality like of these other agents that you had experiences with?
I don't want to badmouth, but I had very bad experiences recently.
Do you
And
do you, but do you, yeah, go ahead.
my main concern is the agents that I am dealing with do not know the contracts. They do not read the contracts. They go off of whatever their company is doing, but it has nothing to do with the contract on the specific transactions.
And wouldn't you agree that these agents are from these bigger firms that are party to these antitrust and monopolistic practices?
Yeah.
They are. That so anyways, I think that wraps it up here. What do you think? What else would you want to add here?
Um, I don't know. I think just if you have questions, just talk to us. Um, Even if you don't want to go with us, but you have a question, just call us and we will be able to at least like resolve the concern or maybe even change your mind. Who knows? Because it's always good to talk to multiple people, multiple agents, not just go like you have a choice.
Yeah. Sold2000.com is our website. How can people contact you?
Oli at sold2000.com.
Yeah, check out our website. That's our sales side. It links over to our mortgage side. This is the fund2000.com mortgage podcast. That's our mortgage website is fund2000.com. But today we were mostly talking about sales, and that our sales site is sold2000.com. Uh, Earlier today we were talking about non-judicial foreclosures. We have a website for that department. It's tdprocessing.com. TD like trust deed processing.com. Thank you everybody for listening. Thank you, Oli, for joining me.
Thank you.